So I'm just going to wait for it to start. Okay, I think we're good. So I'll go ahead and get us started. Just give me 1 sec so I can mute the other video. So there won't be an echo. Okay, great. So good afternoon, everyone. Welcome to the second seminar of the Jewish Federation's Professional Advisory Council, as we like to say PAC, of the 21-22 year. So it's our Preserving Wealth series. And this seminar is titled, What Issues Will Arise as I Plan for Dealing with My Parents' Estate as well as my own? So my name is Shannon Small. I'm the Assistant Financial Resources Development Director and Foundation Director for the Jewish Federation of Nashville. I will be facilitating and moderating today's seminar. The PAC is a group of attorneys, accountants, financial planners, insurance brokers, and wealth advisors that provide education to the Jewish community related to wealth transfers to families and for charity. I will be emailing out the information from the presentations today. If you have a question, we'll take questions for our Q&A time after the presentation. But at any time, you can use the chat feature. You can send it to everyone or just to me if you would like your question to be anonymous. If you don't want to use the chat feature when we're doing our Q&A, feel free to take yourself off mute to ask questions. So the first half of our program will be presentations. And again, the second half will be the Q&A. So I'm going to go ahead and introduce our two presenters today, Mindy Hurt and Ralph Levy. Mindy is a wealth advisor and Senior Vice President of Argent Trust. As a wealth advisor, she serves select high net worth families with trust, investment, foundation, estate, and family office services. Her main focus is multi-generational family governance and dynamics. Ralph is a senior attorney healthcare practice at Dickinson Wright. He assists and advises entrepreneurs and owners of closely held businesses in operationalizing their business plans, including estate planning, business succession, and tax planning issues. His areas of practice include corporate governance, merging businesses, estate planning and administration, healthcare fraud and abuse, healthcare providers and suppliers, mergers and acquisitions, taxation, and tax controversy. So I am going to go ahead and turn it over to the two of them to present. Did you guys need me to pull up the presentation, or Mindy, do you have it?
I've got it. I can share my screen here. Can everyone see that?
I can see it.
Great. All right. Ralph, do you want to get us started, or?
Yeah. Yeah, the topic that we've been asked to present today is what issues will arise as I plan for dealing in the future with my parents' estates as well as my own. The next slide, please, Shannon. So we're going to cover 3 topics, but the premise to all 3 topics would be that oftentimes as we're working on our own estate plans, in certain cases, the estate plans of our parents are overlooked. In my situation, since I was an attorney, my parents' estate plan were well drafted because I did the drafting. But my wife keeps bugging me that we need to update our own wills. So it's a little bit different from my personal situation. And then the other point is,
Ralph, you may have, can you hear, we can't hear you, I don't think. Can everybody hear Ralph? Or?
That's correct. He must be on mute.
okay. What I said was oftentimes we find ourselves planning our estates, but in certain instances, the estate plans of our parents are overlooked. So if something happens to one or more or both of our parents, who will everything fall on? It's going to fall on us. And the question is, do we have the information to deal with their estates? So we're going to cover 3 topics in the next 20 minutes or so. Number 1, it takes a village. That we're going to talk about the who. Number 2 is get ready for the 3 Ds, which is the what. And third is know where they hold them, meaning the where. So let's go to the next slide, which is the who. So Mindy?
Yeah. So most importantly, is to know that you're not in this alone, and that you should really seek help where you can, get it. And so that team of advisors can include other family members, and then also professionals. On here we list, CPAs, attorneys, financial advisors. What's not listed on there and should be are the doctors. So your doctors or your parents' doctors, depending on what generation, and again, as Ralph alluded to, it fits, for different ages and stages, all this information. So just, seek help of the professionals, and then also community advocates. So in the Jewish Community Federation has resources, JFS, and then our clergy, and then in the larger national community, there are a lot of resources as well, depending on what the needs are. So we have a couple of checklists that we'll be going over with you, and those are just really some guides that will help you and your parents in terms of organizing and just guiding through the process, and just might have some ideas in there that you may not have thought of as you go through it. And then the main thing is just to just get started before it's too late. There's, really just before the need arises. It'll take several conversations, and it's always best to have those conversations really before, there's a health scare or something that you really want to be focused on that, and not some of these questions. And, as a child, with my parent is on this, one of my parents is on the Zoom right now. And, fortunately we're in the business, so these conversations come naturally, but I know it's not natural for many people. And, but to be able to ask a parent, just what happens, if something were to happen to mom, or have y'all thought about, this, and perhaps something happens to one of their friends, and, you can use that as a starting point for the conversation. And, but it's okay, and Howard hear this, it's okay to hold your parents accountable too. Like, you still haven't done your will. This is something that's really important. And, please help me help you with the process, and be a gentle nudge as you go along. And I think some parents are afraid to have the conversation with their children because they don't want to disclose financial information. And just, you can always let them know that, we can talk about this without you giving me all the details. I don't have to know everything, but the more I know, the more we can work on this together. And I think that's really important.
Okay, the 3 Ds. We came up with the acronym disability, death, and disputes. Keep in mind that as we walk through this slide, there's 4 sets of documents that, at least from a legal standpoint, the attorneys always look for. One is financial documents, which would be the last will and trust, which deals with what you own at the time of your death. Durable power of attorney, which happens, what happens if you become disabled and you're unable to make financial decisions, who writes the checks, who has access to the bank accounts, et cetera. And then the other 2 would be healthcare, which would be healthcare power of attorney, and living will, who makes medical decisions if you're unable to make those medical decisions. This applies to both the children and also to the parents equally. Also, there's a long-term care plan, which Mindy will talk about a little bit later. But more importantly, for your parents, as you think about your estate plans, think about your parents' estate plans. Have they been updated? For example, if one spouse has previously died, in other words, you only have one parent left. When were they last updated? Have circumstances changed? In other words, if a house is referenced in the will and that house has been sold, what happens if one child, for example, was supposed to get that house? And because sometimes houses get sold in order to enable parents to have financial resources to move into assisted living. And the point, last point is that Mindy as Mindy alluded to, is have they communicated their plan to you to the extent you have enough information to be able to administer their plan. So real quickly, in disability, if you're unable to make medical decisions, for example, you've had a stroke, you'll need a financial power of attorney in regard to handling the financial matters, healthcare power of attorney in regard to medical decisions, whether and the living will covers nutrition and hydration. So the Tennessee law is that you cannot delegate to a third party the ability to make decisions on nutrition and hydration. That's why there's a second document in the healthcare area called a living will. Mindy will talk about long-term care plan.
Yeah, and so for that, I thought it was important to add, just in terms of, not only just do you have coverage, how, if something happens to you and you need assistance, how will you pay for that? But also just what a parent's desires are. Ideally, do they want to try to stay at home? And is that feasible? Is their home accessible? Does it need to be, reconstructed in areas to be able to, move around freely if they need a walker? And then also just, or do they want to be in a retirement community, and are they far away, and are they open to moving to where you live? And again, so those are just conversations that you hope to have before the need arises.
Okay, then what happens at death? The will would operate to dispose of any assets that are owned by the individual as of date of death. Sometimes there are trusts that are established either during lifetime or under the will that will deal with properties, including the making of charitable requests. We have to put a pitch in here for Shannon's employer so they can continue to sponsor and pay for lunches. And I have to check on my lunch because I just walked in. Dispositions of personal property. I was just over in probate court, and there was a hearing before the judge as to whether or not an item did constitute personal property, or whether or not it perhaps constituted business property. The importance of asset titling with beneficiary designations. Judge Kennedy, in remarks on another case, mentioned that a lot of times people think they're disposing of assets by the will when they've gone to the bank and designated a child, for example, as the beneficiary of that account on date of death, and it will pass by operation of law. So that's totally different than what the parents intended, but because those assets are not part of the probate estate, they would not pass under the will. Disputes. Anticipate and be proactive. Simplify while you can, and write down and communicate your wishes. My classic example, one of my classic examples, my grandmother promised the same diamond ring to 3 different grandchildren. Luckily that was done orally, and there was nothing in the will that had conflicting dispositions. But oftentimes, if you've got a set of items, I call it stuff, tangible personal property, that you want to dispose of, make sure the parents prepare a list or something in writing, so that you understand who's supposed to get what you want. One time a client asked me to draft a will, and I said, I'm going to leave the 4-poster bed that's in my family to my husband, but if he remarries, I want it to go to my children because I don't want him sleeping with another woman in that same bed. That's an example of how you can simplify and cut down on disputes. Anything else on the dispute area, Mindy?
Yeah, actually, before, I just want to go back to the other D of death and just highlight, with the titling, that a lot of times we'll see a parent and a child go to the bank, and they'll get with a teller who maybe is doesn't really understand, the ramifications of what they're advising. They just know their little piece, and they'll say, just make it a joint account, and you can sign checks on it and everything. But yet, they don't understand that means that those assets would flow.
Fred Terry Jr.
Shannon, can we mute? Oh, we got it. They don't understand that those assets then flow to, the co-owner, and don't follow the will, versus if, they're a signatory on the account, then that does not mean that it goes to, it would still flow through their will. We also, just in terms of the accounts we see at Argent, IRAs, in terms of how they flow, life insurance, payable on death accounts, all of those flow based on beneficiary designation, and not your will. So it's good to kind of distinguish the difference in those two types of assets and the way they flow at death. And then also with the charitable bequest, I just wanted to highlight, don't let your support of various organizations be a surprise to your children. So again, you don't necessarily have to share the dollar amount, but I do think it's important that you let them know that you haven't intentionally, either during your lifetime with a significant pledge or in a bequest in your will, made these gifts, and it's, especially if they're significant, and the children were unaware, it can create some conflicts that really should not be intended. But with the last D of disputes, the one thing I'd highlight there is just, again, with that, writing down and communicating the wishes, the idea of a personal memorandum. So many times, it's almost always alluded to in the will, and yet so many times nobody does anything, except for the examples Ralph just gave. We don't see a lot of people actually taking advantage of that, and it can help, with minimizing the disputes that might come down the road. If you have said, handwritten, I want this ring to go to this child, and then there's just no question. We have also seen some people do videos to kind of share what's valuable or of emotional value to people. And Ralph, from a legal standpoint, those really don't hold up. Is that correct? But can be helpful.
That's correct. But I think there will be evidence if there were a dispute that's held in front of the court, because that was contemporaneous and it was done while the parents were living. Yeah.
So, and then again, back to the anticipating and being proactive. If you think about who you're going to name as power of attorney during your lifetime, is that going to create conflict while you're still living? Does that person know that they're being named, and are they comfortable with that? Again, if you could communicate that ahead of time, then that's less surprises down the road. Same thing in terms of, if you're going to name someone executor or trustee of your estate down the road, especially the executor piece, we've seen some conflicts where one child is named executor, and in terms of, personal property, how things get divided, it's that executor's decision. Well, that means potentially that they get to choose themselves for the coveted, piece of jewelry. And so, again, the more you talk things through and lay things out ahead of time, I think it really can be helpful.
Yeah. One other point before we move on to the next slide is that if, for example, you've got a situation where one parent is deceased and there's been an inherited IRA, and then the person who inherits the IRA or sets up the inherited IRA designates as let's just say three children as beneficiaries. They put the names of those individual children in the instrument before the investment company or investment banker or the bank, whatever it is, whoever is administering the IRA. And if, in fact, under their will, they did not want one of the children to get the assets outright, but they wanted it to be in trust, then upon death, 1/3 of that IRA is going to pass to that child outright, regardless of what the will says. So with that, let's move on to the next slide. Go ahead, Mindy. Know where they hold them.
All right. Well, so a little Kenny Rogers throwback here, but in terms of just kind of knowing where the assets are, sometimes if you don't do those checklists and have these conversations, it can be a challenge to know, is the will in the lockbox that I don't have access to, that then, how do we get access to it? And you have to work with a bank that's maybe not as, helpful because you don't follow the checklist. So it can be challenging, and the more you know ahead of time, the better. And so knowing the location of the wills, all the legal documents, the tax return, and whether the tax return was actually filed, down the road, you'll need to know that. Your tax return can give you a lot of clues as to what assets you hold. And another one that isn't on this list, but running a free credit report, that can show you all the credit cards that a parent has, and give you some additional clues there. When it comes time, when they pass away, you need to cancel, or even when, they're slowing down and you want to try to simplify things for them, minimizing some of those credit cards. And then insurance information on here is, obviously you need to know about medical insurance, life insurance, if they have long-term care again. And then the et cetera would be like home, auto, personal property. We see some people who want to, not report for tax reasons certain personal property. And I always say, well, were your parents insuring it? Because if they were, that's something that it can't just disappear when someone is insuring a piece of property. So you have to be thoughtful on that. And it also helps where to look for those assets if you are the executor. We've talked about the inventory of property and the titling already, but it's just such an important point to know, how assets are titled, and also just where certain assets are. So your parent might be someone that leaves things in a coffee can and on the top shelf, and there's a significant amount of money in there, and so just to know where those assets are, so you're not surprised and end up throwing things away down the road when you're moving. And then, not on this list besides the bank accounts and investment accounts, real estate. And then, again, safe deposit box, does your parent have a safe deposit box? Are you listed on there? If, do you know where the key is? And just, as time marches on, that's an important one to make sure that you're on there. It makes things a lot easier, especially if the will is in the safe deposit box. Personal assets, where's the title to cars? That makes things easier to know where that is as well. The electronic information is always an interesting one. I've read a lot of articles about making sure that legal documents have language in there. And Ralph, I don't know if that's kind of a standard for you now to have language in there about electronic assets, but is it something that you have?
My answer is it depends. That's a good legal answer.
Yeah.
What I've started doing in my financial powers of attorney is have a blank. It says my password list is located at, and then a lot of times what the client will do is fill in the file name on a computer. The only problem is when someone tries to access it, the list of the passwords is itself password protected. So you have to deal with that. But then Tennessee has the Uniform Digital Assets statute. So we've started including language in our wills that deal with digital assets, which is what we're talking about. We're not talking about non-fungible tokens, Howard. I know you're going to ask that question. We're talking about digital assets, such as passwords.
Yeah, well, and I mean, but NFTs and things like that are also interesting. Those are probably not as much of a concern for your parents as maybe your children. Just.
Yeah, most parents can't spell fungible. Keep going.
But yeah, I think that raises a good point in terms of older documents may not have anything in there about electronic information. And so, that could be a great excuse as well to go to your parents and say, you really might want to update your documents because I'm guessing this information is not in your current documents if it's more than 10 years old.
So the rule of thumb is go ahead and update estate planning documents should be updated every 3 to 5 years unless there's a change in family circumstances or financial circumstances. That's kind of a rule of thumb, but it's going to vary. 3 to 5 years for someone who's at age 80 is a long time. 3 to 5 years for someone who's in their 40s, right, Mindy, is a little bit less shorter time period. Life is like a roll of toilet paper; it goes faster at the end.
There we have our Ralphism. Needed one at least. So yeah, and then the rewards information. That one is, actually my grandfather had a lot of Marriott points, and my sister was able to still make use of those today because we were able to get them transferred. But to make sure there's value in other types of assets that you don't normally think about, and be able to share that information with people as well.
I've got a pending estate right now where there's a dispute between one of the children was appointed as executor, and basically confiscated the frequent flyer miles and points for himself. And my client, who's the brother who is not the executor, is objecting to that and says that the brother who used that benefit of those assets should compensate the estate for the value of those assets.
Yeah, I mean, there's real value in them, although they're depreciating, I think, as we speak. So the last one on here is contact information for healthcare providers, and along with that would be list of different medications, and one that's not on here that I would add is if you know that your parent served in the military, to know where their discharge papers are, and that can help not only during their lifetime with certain benefits that they can get by being in the military, but then also at death if they want any special treatment during their funeral. So that can also just be an opener to a conversation as well. Ralph, anything else on this one?
I think that's it. Shannon, we're right at 12:30. Mindy, you might want to refer to the checklist and leave it for people to surmise and peruse at their leisure.
Yeah, and we'll send out the PowerPoint and the recording of the seminar to all the attendees, if they're interested in looking through or re-listening, or if they weren't able to come. There was a couple that weren't able to come, so I think it'll be helpful to have both. We have had some interesting questions come in, if you're ready to answer them. And again, if anyone has a question, you can take yourself off mute. You can put it in the chat. Either way, happy to answer them. So one person asked, should you send a copy of your will to whoever your executor is with your lawyer's information?
Mindy, you want to talk about that one first? You want me to?
So a copy of your will to, yes, I mean, I think the more information you share with the most people, the better it is in general. And so absolutely, I'd, share that. I don't know if there was a follow-up.
Particularly the person who's appointed as executor.
Yes.
What I do for all of my clients, I ask them, do you want a hard copy or do you want an electronic copy? Or a lot of times we'll give them both. A lot of times that way we can email it to the client, as long as the clients are know how to use email, which most of my clients do, regardless of age. Then they can forward it on or save it or do whatever they want. It makes it a lot easier than them having to go to the library and make copies at 25 cents a page or whatever it is.
Yeah, there was a follow-up to it when you're ready as well.
Just the only thing I'd add is just, when we're serving as executor or trustee, we actually like to, if possible, even see draft documents so that we know ahead of time. And if there's any questions as we read the document, or, if we have any concerns about how we're going to execute this, we can ask it ahead of time and clear up any confusion that might be there. Because obviously, once it's executed and we're trying to act in that capacity, we can't go back and ask you at that time. So it's always helpful to have that.
Mindy's good at making sure the attorneys don't commit acts of malpractice.
So the follow-up to this question was, if you're sending things to people who are involved, they wanted to know, I think they know that you went over sort of a list of things, but they kind of wanted, what are the musts? Like you really, really, really need to give this person this, as far as like, you really, I think it's like your top 2 or 3, right? Like you have to do this. Was the follow-up.
Where are the original documents? If the original documents are in a lockbox, where's the lockbox key? That's one. Mindy?
Just in terms, sorry, Shannon, so just in
I
terms
think it's
of
in terms of your list, you know, you have passwords, you have, it's like, okay, you really need to give this person XYZ, right? Like if they don't get to the whole list, what should they make sure they absolutely get to?
yeah, so I mean, yeah, it is those, you know, just the original documents are the ones that people are, you know, always seem to be scammering at the worst possible time. And so that would be the key. Also, you know, understanding someone's burial wishes ahead of time is nice, because that's such a stressful moment. And even if they haven't prepaid and all that and planned ahead, just knowing what that is, because you know that's just such a terribly difficult time, and hard to have those conversations when you're already going through so much.
Yeah. And Judy sent a question, and what's the difference between an executor and trustee, and what kinds of trusts are there, and what does it cost to maintain one?
Okay, I'll let Mindy deal with the cost issue at the end. Executor is the person who handles the assets that are owned by the decedent as of date of death. So that'd be what we call the probate assets, the stuff that's, or the items of property, tangible property, real property, whatever it is, that are owned by the individual who is deceased. The administration of the estate is a short-term position, responsibility. Depending on the nature of the estate, it should be wrapped up within one year, 18 months, somewhere in that time frame. The estate I was over in probate court on, because it's a contested matter, has been now open 5 years. So it just, the answer is it depends. A trust, there are two types of trust. There's a trust that you set up while you're living. That's sometimes called a revocable trust because you have the right to change it. But it's an inter vivos trust. In other words, a trust that you set up while you're living. The other type of trust, it would be a trust that would be established under your will, where rather than leaving property outright to your children, for example, because they would end up with the property at age 18, or money, or whatever it is, you would set up a trust, and they get a third at age 22, a third at 25, a third at 28. What else is in that question, Shannon?
Just the cost part.
Yeah,
I'm sorry, the trustee is the person who administers the trust. That could be a longer time period. In Tennessee, you can run a trust up to 360 years, but you're not going to find the same person to serve as trustee over an entire 360-year period.
Not the same person, but you can have an entity serving in that capacity, and they are more likely to live on longer than an individual. So that's why corporate trustees are oftentimes named to have that continuity. And then, you know, to answer the question on cost, there's kind of two tiers to cost. One, there's Ralph and other attorneys' expenses to create the documents, and those vary. And then there's the management of the, you know, estate or trust, you know, once it gets executed. And that also depends on who you name in those roles. If it's an individual, they may not charge, or you know, or they might, or if it's a trust company like Argent, then there's usually a fee structure involved, and it's very similar to, you know, who you might have already managing your assets from an investment management standpoint. So
May I ask a question?
Yes.
No,
Why are trusts created?
I didn't realize you were in here.
Okay.
Are you on call?
Yeah.
Sorry.
Excuse me. Question. Why are trusts created?
In general, trusts are created because the person who sets up the trust doesn't trust the beneficiary, which means, why you call it a trust if you don't trust them? But that, Mindy, is that a fair answer?
I mean, I think it's a little bit cynical, Ralph, but I think sometimes it's not trusting the people around the beneficiary too, in terms of just wanting that asset protection for your loved ones. And, you know, especially if you have multi-generational trusts that live on past what you know about in terms of your children and grandchildren, you don't know whether you trust them or not yet. And it's just protecting them for their futures.
Are there tax consequences?
Yeah, so there can be tax benefits to trust in terms of, generation skipping trust can protect assets from any additional estate taxes for multiple generations. They are taxed a little differently, but usually they are helpful in terms of not having additional taxes and trying to let assets grow without additional taxes being placed on them.
Sally, that's a 2-hour presentation.
Yeah.
Just on that one, to answer that one question. We can't do that in the next 20 minutes.
And thank you for your question, though. It's actually a very common one. The next question is in Tennessee, is it better to have a will and trust, or is it better to go through probate? In other states, it's much better to have a will and trust, but I'm wondering about Tennessee.
Okay, so anytime I have a client who calls me up in about March or April and says, how come I don't have a revocable trust? And I always ask them, when did you get back from Florida? Because everybody in Florida has revocable trust. Now, why do they have revocable trust if they're residents of Florida? Because attorneys get paid based on percentage of and the courts get paid based on percentage of the probate assets. So everybody puts assets in a revocable trust to avoid that expense. In Tennessee, the probate process is fairly simple. So as a general rule, I don't recommend my clients set up trusts, but let everything pass under the will. Now, other members of the PAC have different opinions, and I'm in a law firm that has estate planners in 4 or 5 different states. Tennessee, I'm in the minority, and that's probably because I'm the oldest attorney out of the estate planners in the group. So, but it does vary state by state. My Michigan brethren all use revocable trust. The Kentucky brethren use revocable trust. Arizona uses revocable trust. But my answer for Tennessee is it's whatever you want, and it really doesn't matter. The only one potential reason to use a revocable trust is if you've got assets, or if you don't want information to be public. A revocable trust is not publicly available information. So, for example, for a retired professional athlete whose estate planning documents I sent out haven't been signed yet, we did use a revocable trust because we don't want people in the public to go into and start snooping around, because the public documents that are in the probate court are publicly available.
And Ralph, don't people also do trusts to protect the kids? So, like, if they die and the spouse remarries and has another spouse and all of that, or is that something different?
Sure. No, that's in fact for this professional athlete, we put all the assets in trust because if the athlete dies, we want to protect the spouse against claims of creditors, which could include a remarried spouse, and it protects the beneficiary. But you could do that through a will. You don't have to do that through a trust that you set up while you're living. That was the question, was when and what type of trust do you need?
Yes. So I just wanted to, I generally agree with Ralph on Tennessee, you could go either way, and it's, revocable trusts aren't as important. But in terms of the topic, that we started with, and your aging parent, one benefit of a revocable trust is if assets are already set up in it, and if you're the successor trustee, they can be an individual can be their own trustee of a revocable trust to start. But then down the road, if you become incapacitated and your assets are already in a revocable trust, your child, if they're successor trustee or a corporate trustee or whoever it is, can take over seamlessly immediately when you become incapacitated. And so that is one thing that can kind of help make life easier down the road if you set it up today.
And what Mindy's drawing a distinction is between revocable trusts that are set up today that are funded, as opposed to revocable trusts that are set up today that are not funded. So for an elderly person, perhaps you might want to consider, if you're going to use a revocable trust, go ahead and fund it so that it's ease of administration going forward.
Absolutely. And again, that's one of the biggest issues is, people do a lot of great estate planning, but then don't actually follow up with, again, the titling of assets and making sure that assets get funded based on what your estate plan says. So, that's a key, that this is, this is a process. It's not just a one-time conversation.
Michael has a question, and then I know Howard has his hand up. What happens if you have a Tennessee-centered will and estate planning and you die living in a different state?
So is the Tennessee-centered will one that was executed while you were a resident of Centerville, Tennessee? Is that right?
Yeah, that's what he's talking about.
Oh, I see. No, the answer is if a will was enforceable under the laws of the state in which it was executed, it's going to continue to be enforceable even if the individual moves to another state.
Yeah, great. Howard, you had a question?
Yeah, just some questions, observations for the panelists to respond to. The thought being that probably the most important thing to that earlier question, I'd say, is finding an advisor that understands your family and your situation. The more that can be conveyed, whether that's an attorney, insurance professional, trust officer, whoever it is, working with someone who really does understand this area in depth is probably, to me, the most important item. Another is just, and Sally talked about it, was the tax minimization. It's the unstated goal of everybody on this call is less for the government and more for families and charity. And I can't emphasize enough, when my dad before he died, I asked my mother, can we change his will? He was leaving gifts to charities. And she said, what do you want to do? I said, I want to take the charities out. And, oh, he wouldn't like that. And I said, yes, but if we take it out of his will and you make the gifts later, we'll get both an income tax deduction and avoid estate taxes as well. So understand, if you have good advisors that can look at your own situation, there are win-win-win situations in many of these areas. And I'd also note that working towards simplification as clients go from 50 to 60 to 70 to 80, the simpler you can make it, the easier you make it on everybody, and that's appreciated. And the final note, I would say that everyone here should blame Mindy and Ralph. If you want to raise this issue with your parents and they've been resistant, say you've been to this seminar and you're working on your own documents, but certainly the people on this call feel like your documents would be better if you knew what the senior generations were approximately doing. So just some thoughts, any reactions?
Yeah, it wouldn't be the first time I play bad cop for families that we work with. So we're always happy to play that role. And that's a good point too, in terms of some of these conversations, you may have selfless reasons for wanting to do, to see what's in your parents' estate plan. Perhaps you don't need the assets and you want it to go to charity. So there are many reasons that you may want to have that conversation with your loved ones.
So Howard, Mindy just wrote an article. It was in the Observer that came to our house, I think on Saturday, that talks about how you fund charitable bequests. And also I talked about a little bit in one of my prior articles for the Observer. So if anyone's interested in either of those two articles, Shannon can send that to you. So send Shannon an email requesting that.
I can include those links, Ralph.
Sure.
In that, the follow-up email, I'll include those links.
So for example, all assets are not created equal. If you want to make a bequest to charity, you're much better off making the charity a beneficiary of an IRA than leaving them assets under your will, for example, because the charity does not have to pay income tax on receipt of those assets, whereas an individual would if you make the individual the beneficiary of an IRA. So keep that in mind.
Shannon, were there other questions? Or?
Yeah, we have another one here from Judy Beth. She says, setting up a trust can promise assets to charities while providing tax advantage sooner, but how does one maintain the trust in the meantime?
Maintain the trust means you just have to pay the trustee fees. And a lot of times, if for example, it could be a charitable remainder trust where the assets benefit an individual while the individual's living, and then upon death of the individual, it goes to charity. someone has to collect the income off of the assets, be it stocks, bonds, real estate, whatever, pay the individual who's serving as, who is the beneficiary, and then turn around upon death of the individual and pay the money to charity. And it takes a trustee fee unless you're using an individual family member to serve in that capacity. And you've been given the family discount, so to speak. Mindy?
That pretty well covers it on that one. If there weren't any other questions, I'll just take a minute to show just a couple of the checklists real quick, and that might be good resources for people. This is one that just we use at Argent, and you'll have access to that with the email. I wanted to highlight this Age Well Resources. It's a website based in Nashville, and there's a bunch of different material on there. The Preparing and Planning for Life's Final Chapter is a 48-page document. It talks about funeral arrangements, essential records worksheets, who to contact. So that could be a guide for you guys if you have these conversations with loved ones. The Aging and Caring is another one. That's 177 pages. It acknowledges something I think is really important is the frustration for a parent to be, losing capacity or knowing that these things are happening to them. And just, it gives you some guidelines in terms of the do's and the don'ts for talks with your parents in a family meeting setting. It also has a checklist for if you want to stay at home and, inventory, things that you need to think about. So there's a lot of good resources on this website. And then this last one is just a website that's called Lifefolio. And it really has a lot of different questions that are not only about the assets and the legal pieces, but also just the legacy and the values that you want to leave. And so just some interesting questions. To me, these are almost icebreakers that can help with some of the conversations you would have with loved ones. So.
Great. And if you do have any other questions, now would be the time. We have just a few minutes left. And if not, I can wrap up early, and then I will send out the follow-up email with all the information, including this recording.
Shannon, one issue I thought of after Mindy finished is, and she mentioned burial instructions. In other words, where do you want to be buried? Do you want to be cremated? Do you not want to be cremated? If you want to be cremated, who's going to get the urn, or is the urn going to be buried itself? But the other collateral aspect, as a former chair of the cemetery committee at the temple, is where are you going to be buried? So a lot of people will assume, for example, that they can be buried in the family plot. But if that's the case, you better make sure there's enough openings in the family plot for you and your family members. If you want, for example, your spouse or your children to be buried next to you, make sure that you identify where you're going to be buried and whether or not you have the legal right. So, for example, there may be restrictions on who could be buried at a specific site. If you're talking about being cremated, and you're talking about burying the cremains in a normal grave, is there a limitation on the number of cremains urns that can be buried on the same site? So that's one aspect. Or if you prepaid for funeral services, it's a good idea for someone to know that. Otherwise, they run the risk of going to a different funeral home and end up having to pay for the same service twice. And we're not talking about a reinterment, paying basically twice for the same burial.
Yeah, and the other part that, especially just in the Jewish religion in terms of cremation, I mean, that, I know someone in my family wants to be cremated, and I was like, well, you better let that known to, other members, because, I don't want to be the only one to know that, especially because, there can be different schools of thought in terms of whether that's appropriate or not. So, just again, back to communication.
Great. So I'll go ahead and wrap up now. I just wanted to thank Mindy Hurt and Ralph Levy for presenting and answering questions, and to the Jewish Federation, Jewish Foundation of Nashville and Middle Tennessee, the Joe Kraft Professional Advisory Program Fund, and the Harris A. and Diane Gilbert Area of Interest Fund for Education for all supporting today's program. And I wanted to thank all of you for joining us. We hope we've given you some valuable information that will assist you in getting started or continue financial and estate planning journey, as well as empowering you to fulfill your philanthropic passion and commitment to leaving a lasting gift to support the Nashville Jewish community. So if you're interested in signing up for future seminars, once the new registration link is up, I will send it out. On our website, the PAC website, jewishnashville.org/ways-to-give/PAC, it has the brochure and the roster with all of our PAC member information on it. And also, we'll post information about the next Preserving Wealth seminar on we'll do it on the Fed Focus, the Observer, social media, and again, I'll email out all of the information. So I just wanted to thank all of you for coming. And again, I will be sending out information this afternoon with all the links that you would need, including the link to the PAC website in case you would like to have the roster of PAC members. Thank you so much, everyone, and have a great rest of your afternoon.
Thank you, Shannon.